both should be seeing that then. Oops, how do I get that little? There we go. All right. So I'll just wait. I mean, I guess if there's no ruling before we go to the press, go to press on this document, as it stands, it reads okay, and we just have to be aware that we might need to do an addendum if the case comes out differently somehow.
Yeah, I guess it reads to me like there is not a claim of innocence. Like, I think that's a little too strong.
Mm-hmm.
I mean, I guess that could, let's see. I mean, I guess, yeah, if they decide there isn't one, then this works.
Yeah. I guess
Otherwise,
this
just
last sentence, I mean, a recognized claim for post-conviction relief could include innocence. If the court recognizes it.
maybe we could just put in a sentence at the beginning, or like part of this first sentence, counsel should understand, like may or may not itself constitute a cognizable
Yeah.
claim, conviction relief.
Yeah.
And then like put a
That makes
period
sense.
instead of the comma, and then nevertheless, its relevance to the case, or like, I don't know, either way, something like that. Or regardless, maybe regardless.
While a client may or may not, maybe we just leave it.
I almost wonder too. I don't want to overlap too much, but even if we said actual innocence may not, if we attach it to jurisdiction, because I think federal habeas does recognize. I mean, I've seen some cases that do, but I know this is post conviction specific, so I don't know if we wanted to just kind of flag it for jurisdictional purposes.
What about that?
I think. Yeah, that's fine.
Okay. We can always come back to it. Or maybe they'll rule in the next 3 weeks.
Yeah, or even say as of December 8th, 2025. Yeah. I remember they did the Watkins case in December. Is that common? They'll do a big case in December? Or?
I think that does happen yeah. I mean, yeah, it's like about the right time for it to come out, so we'll see.
All right. Let's see. Meg, you said why we could make this stronger.
Oh yeah, this was like ordinarily should not have represented the petitioner during a criminal trial or direct appeal. Is that?
Yeah, I think this you probably went over. I think you all went over this before I started coming to the meeting, so I didn't. That's the language we had. I didn't want to mess with it too much. I didn't know. I mean, I imagine there are theoretically times when, like, maybe trial counsel, someone gives them like the Brady file, and you're like, well, that's obvious. I should go ahead and try to take care of this for my client. I mean, probably you shouldn't if there's also an IAC claim.
Yeah, you still should. Or I mean, you still have an obligation to investigate all the IAC ones.
Yeah. So just take out ordinarily.
I like ordinarily because what if you had somebody who was long-term represented him on post conviction, got him reversed, did and then was going to represent him in trial or represent him on appeal. I mean, you might have someone intimately familiar with case and client, and also improprieties in trial or retrial. So I think there's a few exceptions where you might not be.
Could we maybe? Yeah. Could we change it to like except in extraordinary circumstances?
Yeah, I'd agree with that for sure.
And then take out ordinarily.
Yeah.
Yeah.
Great.
That's good. That makes me feel better. Thank you.
Right. Just going to scroll down to any of the outstanding comments, but if y'all see anything I scroll past you want me to stop on, let me know. Okay.
What did I do? I think maybe I just moved things around for this one.
Yeah.
And then, yeah.
Yeah, because those are all crossed out,
Right.
so you must have moved those all up.
Or just like to make it flow a little more clearly.
Yeah, yeah.
I think it was just like in the order of our brainstorming. Yeah, let's see. And is this is client communication? Is that right? What standard is this?
Yes.
Okay.
Yeah. So I guess the question is, does this number 2, which says should keep the client informed and consult with the client concerning amendments and challenges to the pleadings, to what extent does that adequately cover work with the client to develop the claims and provide an explanation of what claims are included? And then how, to what extent you're explaining omissions.
Those are, I guess, yeah, these are coming from issues I've encountered. Like once the case gets to me on appeal, the clients haven't fully understood these things. So, I mean, yeah, I guess I don't know about like, Ed might have a better sense of like working with the client to develop the claims. I don't know if that's like a good way to say it or if 2 kind of covers that part. But as far as like, I think maybe just like sub points in 2 could be like providing a clear explanation of the claims that are in the amended petition. And then that second paragraph from my comment.
Yeah, I don't have any issue with how that's written. And it's kind of twofold. I think we cover in the church be glad in the section, but one of the things that, I think we cover it, but we have to let them know what claims are being filed because they'll have issues of when they have to address church be glad, and it is kind of a lot of times or it can be almost counterproductive trying to be too collaborative with the client on technical legal claims, but also I don't have a problem with how this is written. I think the intent and the meaning comes through.
Yeah, that was what I was kind of wondering about with the like developing claims. So I think, yeah, leaving 2 as is and then just including the like explanations. That's good to me, I think.
Great. I can probably accept all this. Good catch. I will go back through and fix all those hyphens or non-hyphens.
Yeah.
Or maybe neither, as in the footer. Is there do you all have a reference rule? I imagine it's in the bench book
Yeah, what
to
do
see
we
what
do?
they do. Well, I'll figure that out. I'll look to see how it's referenced. Okay. So here in litigating claims, we discussed oh yeah. I thought I remembered somebody, possibly Ginger, but maybe not, saying that the witness, that the expert would have had to have been an expert at the time.
Yeah, I made a note to that. She did, and I said something about authority just because, I could see, I haven't seen that as a specific authority. I could see a situation where unless that's a clear specific authority, I wouldn't necessarily want to exclude a good expert. But Ginger, I recall as well that Ginger said that was like a ruling. I'm just not familiar with it.
I think I added in those two cases, the Hale v. Valque and New York v. Armenicus.
Thank you for doing that.
Which I think is getting it, like would have been available to testify.
Mm-hmm. But is that the case for an expert witness?
Yeah.
That seems, I mean, I could imagine a hypothetical in which any expert who is dead and someone with the same expertise reviews the same thing.
Yeah, I
and
mean,
that expert is alive.
If you had evidence, the court's been pretty strict about it, of like needing to have evidence that, like, what that dead expert would testify to. So like if you can put on evidence from a different expert, but say like, I wouldn't have been available, but this expert that trained me would have been, and this is what he would have said, like that's probably enough. But you do have to be like pretty specific, it seems like, or at least that's how the Court of Appeals has been going.
And it's not gonna be a lot of an issue because of non-unanimous verdicts. In the last couple of years, I've had some cases that were really old, but that's not going to be the norm.
Right.
So
Right.
the appellate process can be a little slow, but I'm much less thinking about it like in this context of some of these really old cases. That's not going to
Totally.
be.
I suppose that's yeah.
Yeah, I mean, there definitely could, every so often you get really old, timely petitions that could run into that kind of issue, but it is pretty unusual. And I think there would be like ways to get around that, but that is the general rule.
All right. Well, then I guess we should put it there. It's not necessarily intuitive.
No.
Pretty sure that is for experts. That's not a rule in Louisiana.
Oh, interesting. Yeah.
Let's see. So this is during trial. Anything about presenting testimony in cross? We have much more detailed commentary in the habeas standards.
Yeah, I was just like having just done the habeas, reviewed the habeas ones, just noticing that this is a lot leaner, which is maybe fine. Otherwise, I think the habeas ones are pretty generic, so probably wouldn't be that hard to just like.
I can go take a look at those. I know Jordan shared them, but it's a good point. I didn't look at that section with the thought to make sure they line up.
Yeah, I remember that being pretty extensive. I think part of it is that I think most of the habeas cases are medical habeas, and almost all the witnesses are medical personnel from DOC. So that's like the cross is big, and in PCR normally like the most frequent testimony is declaration from trial counsel that was if not entirely drafted, massaged by the Department of Justice. So, I mean, you should, but yeah, I don't know that the detail would be necessary because of the kind of witnesses you generally have in PCR. But I wouldn't be opposed to adding all that either.
No, that's a good point, that like these trials just aren't nearly as involved as habeas trials. So I don't know, it might be worth like taking a quick look at them and seeing if there's anything that seems helpful, but it's,
these are very petitioner driven versus like the habeas a lot of times like defense driven. They're defending it hard, and here it's like putting on our evidence. So
yeah.
That makes sense.
It's fine with me to leave it as is too. Either way.
Okay, I'll take a look and see if anything makes sense to add. Wow, we're flying through this. Okay. Add to the black letter portion what to do after win or loss. So, like move from the, is it in the commentary now?
Yeah. Right. I think it's in there somewhere, hopefully.
Yeah, I think immediately.
I guess that just seems like it's not just a suggestion, it's what you have to do.
Yeah. So basically move 3 into black letter is the idea, right?
Yes. And 5. Or I don't know if there's like a better way to summarize what to do in the black, but I guess it just sort of makes sense to me to include that all in the black letter.
That later. Wait, oh, how did that happen? There we go. And then add a reference to the OPDC process. I can do that. Okay. That's easy enough to do. Okay, well, that was all the outstanding comments. That's pretty good. Anything else y'all wanted to discuss today? If not, I can incorporate all this. I'll fix the hanging things we just discussed, and then I'll recirculate. We'll see if Ginger has any comments. And then does the 22nd work for you too for a final look through?
Let me pull up my calendar.
Yeah, that should be fine.
I may have to, I have a deadline that day, so I may have to just respond. But if I'm not there, I'll send any comment I have by email.
Okay. Well, I guess we'll see as well if that date works for Ginger, because if not, it might just be me and Meg, and maybe we could find a date that works for more folks. But I'll try to send out the updated standards and see if the 22nd works for Ginger, and then get a date on the calendar the next day or two.
Sounds good. Thanks so much.
All right. Thank you both. Quick meeting. Enjoy the rest of your day.
All right. You too.
Bye.
Bye.